5 minutes past 10. It's time for David Whiting to help you with free legal advice, as he does at 10 o'clock on a Tuesday. 1300 222 774. 1300 222 774. And David, good morning to you.
Good morning, John.
I've just made a cardinal error.
Oh?
I've just accepted the offer of a biscuit baked by our boss.
Oh, wow.
And he's brought in some biscuits and Sally has come round and offered them to everybody. And foolishly I said yes, which means I've got a few crumbs still.
Right, okay.
So if at some stage I start to cough, it's because they're sort of Anzac-y almost, aren't they? They're sort of Anzac biscuits. It's the wrong time of year, but we'll accept them anyway.
Right.
We're cheap in here. But they're very nice. I must say, Damien can bake, so there you are. Congratulations to him.
Now, John, last week...
Were you not offered one?
No, I actually have given the production team chocolate.
Oh, have you?
Yes.
Oh.
All right. And I've given them chocolate because last week my phone went off in the studio.
It did.
And you told me that the price was a slab.
I did. Yeah.
And I decided that I really didn't want to walk down from the city with a slab on my shoulder, and I wasn't sure that in fact I could. So I thought that what I would do is come up with some payola that I thought was equivalent.
What, chocolate for Katrina and Tim?
Well, and for everybody, you've got four in your production team. They've all got chocolate.
Florence gets some too.
Yeah, absolutely.
Oh, right? He's normally ignored.
No. He very kindly gives me a copy of the radio program on a Tuesday afternoon, so I'm not ignoring him.
No, on the contrary, he should get double.
Yes.
Yep.
Well, but on the other hand, John, I've given you this. Now, this is a little black box that contains something that rarely seen outside the C-suite at the ABC.
So should I open it now?
You should open it now, John.
Okay, it is a black box. It is the size of a sort of box that you might give someone a very expensive watch.
No, it's not. It doesn't weigh anything like that,
No,
John.
it doesn't. No. In fact, it feels like it's empty.
No, it's not empty. Right?
Okay, I'm opening it up. Oh, now you have to describe.
Okay, John, it's a ABC tie from the mid-90s. It has never been worn.
Where did you get this?
I can't tell you. That would be giving away a secret, but I can tell you that I came across it lawfully.
An ABC logo necktie.
Yes. But back in the days when presenters wore neckties.
I remember asking Randall Matheson, our then state manager, who had one of these, where I could get one too.
Yeah.
And
but you didn't ask me, John.
So you have the
I've had that
stash.
for 20-something years.
And it's never
I
been
have
worn.
never worn it. And there you go. I thought, my phone went off, so there you go.
Now, thank you, first of all. That
goes in the mullet book, doesn't it, John?
Well, no, I'm not going to do anything except occasionally wear it.
Yep.
And I don't often wear a tie, but when I do, I have some that I stole from my father.
Yes.
I have one that they presented to me, which is from the school I used to go to at Melbourne High.
Yep.
And they gave me a Melbourne High Old Boys tie, even though I've never been a member of the Old Boys. The Law Institute presented me with one. I feel like
one of those, yes.
Complete hypocrite if I ever wear that. I've got a couple of other novelty ties, including one that's got a whole lot of little Mickey Mouse faces on it, which you don't realise they're Mickey Mouse faces until you get right up close to it. But that goes right to the top of the pile.
Okay, I'm very pleased.
And I am enormously excited by that.
Your production team says I can leave my phone on all the time. They're very happy if it goes off. John, I've got three brief things to talk to you about today.
And a photo of the tie will go on our Twitter account. Is that right? Is that what we're doing with it? Yes, very good. Thank you.
Okay, and it's fashionably thin, John.
Oh,
so,
well, even better.
It is on we think made about 1995.
Okay.
But not been worn.
Ever?
It's not been worn ever, no.
Ever. Well, it's going to be. I'm not going to put it in sort of, I see, woven and manufactured in Australia by somebody or other.
Yep.
Okay. Thank you.
Done. Pleasure, John.
Very excited.
Now, the Supreme Court in the last 24 hours made a decision in relation to a claim between a California baker who wouldn't make a wedding cake for a same-sex couple.
Yes.
Now, it's an unsatisfactory ruling in the sense that it was not made on the fundamental question of whether or not a religious freedom under the American First Amendment allows you to not make a cake in those circumstances, but it was based on a really narrow interpretation which the court described as an anti-religious bias contained in the Colorado Civil Rights Commission.
So if they sent it back to the lower court to reconsider...
No, the answer would be he doesn't need to. The decision was wrong.
Right.
So it's not been sent back, but on a 7-2 majority, it was rolled on the basis of the court was biased in the decision that it made. So it doesn't answer the question of whether or not your religious freedoms are fully protected by the First Amendment. They say it's a question for another day.
All right, and just to interrupt you for a moment, apparently Barnaby Joyce has done an interview on Sky News and he has said that he will recontest his seat of New England. So that's just breaking news at the moment. Barnaby Joyce says, no, I'm not going away. I'm hanging around and I'm going to roll through at the next election.
The next one, John, is you realise that you can in fact trademark a scent or a smell. It doesn't happen very often and it's quite difficult to do.
And they've done it with sound as well. For instance, an iconic motorbike brand protected the sound of the exhaust of their motorbikes.
Yeah. So the example given on the IPA Australia website is the...
IPA being the intellectual property.
It's an arm of the government that registers trademarks, copyrights and designs.
Right.
And it's there are... eucalyptus radiata scent applied to golf tees is the one which is given here.
What?
Yes. So a plastic golf tee with a wooden smell. I don't know, but the use of that smell when applied to applied to golf tees has been trademarked.
So you can open a packet of plastic golf tees and they'll smell as if they're made of wood.
Well, that I'm imagining that's what it doesn't say what kind of golf tees they're applied. They could be pine golf trees, but they'll smell like eucalyptus radiata. So, but in America, last week, Play-Doh, the smell of Play-Doh is now trademarked in the United States.
What is the smell of Play-Doh?
It's described as being sweet, slightly musky, vanilla fragrance with slight overtones of cherry, combined with the smell of a salted wheat-based dough.
I'm so glad I asked. Oh, dear.
And my last one is also from America, John. If you were going to a major hamburger chain, it's possible to buy a thing called a quarter pounder.
Heard of it.
Okay. It's also possible to buy a hamburger and a cheeseburger, the difference between the last two being a layer of cheese.
Yep. Well, it's sort of... Is it really cheese?
Well, let's call it cheese for the purpose of this.
Yes.
What's happened is that someone has taken that hamburger chain to court in the United States because if you order a quarter pounder without cheese, you don't pay less.
Right.
So the answer is that the argument which is put is that they are biased against those people who don't want cheese in their quarter pounder, and there ought to be a price differential, so it's a price gouging exercise.
Right, so this is the decline of Western civilization as seen through the prism of a cheeseburger.
Yeah, that's about right.
I do remember once asking the head of the ACCC why they weren't taking proceedings against the Golden Arches, because I have never seen one of their products that in any way resembles the pictures they take of them.
You're not watching Checkout often enough, John.
Well, it was years before Checkout had even been imagined, and I think the answer was something like, we've got more important things to do.
Gee whiz, that would have gone over well.
Yeah, it did. Ian in North Carlton, good morning to you, and welcome. You're through to David Whiting.
Morning, Ian.
Good morning, David. I've got a question about wills. I know you've had lots of them before, but we're a couple with no children. Each is the other's sole beneficiary in our wills.
Yes.
But if we happen to sort of die together, it goes to different family members and charities.
Yes.
My question is about simultaneous deaths, such as in an aeroplane crash, where you can't determine.
It's actually reasonably complex, but your starting proposition is that if you can't work out what order people died in, you're assumed to have died in order of age.
That's what I thought.
Right, so
yes.
that's a statutory provision.
So the older one dies first,
yes,
and that triggers, even if there's not 30 days between them.
Well, no, that triggers, if everything that's jointly owned, you would look at the asset, you look at the will of the second person to determine who inherited. But there's an assumption, a rebuttable assumption, Ian, that says that if people die, that the expectation is that if you were to leave me $1 million in your will, there's an expectation that you only intend me to benefit if I last 30 days beyond you.
Yes. Yes, actually it's written in to say as long as we survive each other by 30 days.
Okay, well then the answer will be is that everything that you jointly own will, and you die simultaneously, will be dealt with under the will of the second person. Items that you own on your own will be dealt with under your will in the circumstances you've described.
When you say you're assuming I'm the oldest, is that right?
Yeah, I'm afraid so. I'm assuming that your marriage is much like most people's.
Well, in fact, it's not, but it doesn't matter.
Okay.
Then let's substitute that in to make it absolutely clear. The property owned individually by either of you
will be dealt with under your will, under the will maker's will.
Under the older person's will or the younger?
No,
each
sorry.
individual person's will.
Let's assume you own some Commonwealth Bank shares and you jointly own a house and your partner owns some Telstra shares, right?
Yeah, good. Yep.
What will happen will be is that the house will go under the will of the younger person.
Yes.
And the Commonwealth Bank shares will go under your will and the Telstra shares will go under your partner's will.
That's very clear.
All right.
But instead, if you want to, you can rewrite each of you your wills to take into account what you want to happen if you die together. You can make provision for that if you need to.
Does that override the law that says that the second person is assumed to have died first? If we actually write
so your will, what you're really doing is you're talking about saying this is how we want things to operate when we're both gone.
Okay.
All right. Now, you could, if you really wanted to, write a will that was you could write a will for every day of the week and every hour of the day. But, some people say, if I die first, then my partner gets everything and can do what they like with it. Yep. Other people say, we both want to make wills so that the ultimate beneficiaries are the same regardless of who goes first. And every individual's entitled to make the will they want.
And indeed, I've seen wills where people have said, I make this will on the understanding that my partner is making a matching will, but if indeed my partner changes his or her will, then the following provisions apply instead.
Oh, right.
Yeah, that's a bit hard when you've died, but, I understand the sentiment, yes.
Where's the property law, I think? Well, I think it's the property law that says the joint property...
Joint property goes to the survivor outside the will, so the 30 days has no application.
So what I'm getting at is if we wrote into a will what we want to happen if we die simultaneously, would that override that property law?
Yeah, because you've made a different provision. So, no, it wouldn't override the property law, but your will would say, look, if we die simultaneously, then this is what happens to the house. And you put that provision in both wills.
And each of us have said the same thing.
Yep.
Okay.
So that is in both wills, whichever will is the one that is to be acted upon, okay?
Okay, yes, that makes
sense. Thanks, Ian.
Thank you very much.
And then it comes down to trust, David, whether your partner secretly makes a later will that undoes what you thought was a joint agreement.
Yes.
And that's been known to happen too.
It does. Every now and then you've got a couple, particularly when you've got blended families, and they come in and they make promises to each other that make wills in a particular form that are enforceable. And
we're seeing litigation in the New South Wales Supreme Court at the moment over the Norfolk Island lawyers' attempts on Colleen McCulloch's will to leave her estranged husband out entirely.
Yep.
And that's getting particularly nasty. In fact, the lawyer in all sorts of strife for behaving in what would, on the face of it, seem to be a most unethical way.
I haven't read. I've only read superficially, John. Haven't read the detail.
She produced a fake will to show the ex-husband in order to give him the feeling that he was to inherit.
Oh, wow.
In fact, there was the intention, as expressed, according to the lawyer, of Colleen McCulloch to leave her money to an American university, but she wanted to get her ex-husband off her back.
Wow.
Or the lawyer did, whether it was done on Colleen McCulloch's instruction or not. But the lawyer, very embarrassed in giving evidence and saying, I unpicked the will and substituted a page to show it to the ex-husband.
Oh, how horrible.
Well, yes, if that lawyer is a Norfolk Island practitioner whose future, I would have to say, is looking a little wobbly.
Well, someone presented a will to me the other day that looks a bit dodgy, so I'll let you know in due course.
Okay, thank you. That'd be very interesting. Peter in Geelong, good morning to you.
Hi, guys. How are you?
Peter.
Can you tell me, please? I engaged a lawyer, wasn't happy, went to Victorian Legal Services Commission and said he'd charged me too much and wasn't happy with the result.
Yep.
Victorian Legal Services come back and said, yes, he charged you too much. We'll correct that situation. If you're unhappy, take him to VCAT with the other part of the problem, as in he didn't get a good result. How long have I got to take him to VCAT? Is there a time frame?
There is a time limit, and I can't tell you what it is, Peter, but I will for next week.
So it's not like a year or two, or you really don't know, David?
I don't want to. I don't think it's a long period, but I'll let you know next week.
And with that, I know I've listened to you religiously, sort of thing, and I heard you say about
please don't listen to us religiously, Peter.
Mm-hmm.
Well, constantly anyway.
Otherwise, you'll lose your faith in religion. Yes.
And you said something about a month ago about advocacy immunity.
Yes, there is this is one of the only jurisdictions in the world. It's based on an English premise that you've got a barrister standing up there and presenting your case as best he or she can, and if they make a mistake in the course of the advocacy, they shouldn't be held responsible for it. Rather, you should, the client should.
And that's
gone. That's gone everywhere but here.
A rule made by judges who used to be advocates.
Yes.
I was told after I heard you say that it was now squashed or gotten rid of in 2016, so maybe you've got 2 bits of homework.
Okay, well, I'll take that on board. I do know that the High Court had the opportunity of considering it and they found in favour of it not that long ago, but I will take it on board, Peter, knowing that you'll be listening consistently. Next week I'll give you the answer.
Darryl in Brighton. Morning, Darryl.
Morning, John. Morning, David.
Welcome.
Live in a small block of 5 units with a common roof, and possums have entered the roof cavity.
Yes.
Is that an owners' corporation problem or individual owners?
I haven't seen your plan of subdivision, but I would be guessing, in fact I'm almost certain, that it will be an owners' corporation issue, because my expectation would be that your unit is in fact, the top of your unit will be your ceiling.
Right.
But what you do is you can order a copy of the plan or get one from your owner's corporation manager, and it will show you what you own and what you don't own.
Right.
Have you had a meeting about it, Darryl?
Not as yet. We're trying to work out who's responsible. Is the roof a common property?
Almost always. It depends on what the plan says, but the general proposition is that the roof is common property.
Do you know where they're getting in?
We suspect where they're getting in.
But you have to, if you're going to patch one bit, you've got to patch the lot, don't you?
Correct, yeah.
So it's everybody's problem.
Yeah. And there was a party wall between, say, Unit 5 and Unit 4.
Well, it's a common wall. It's not a party wall. Right. And under the old plans of subdivision, the boundary between the 2 units was the midpoint of the wall. Under new plans of subdivision, the wall is common property and you own to the face of that wall, but with a licence to put things in it to hang pictures and the like.
Yeah, we also suspect that they're in other units as well, cavities.
Yeah, well, I mean, it's that whole thing. If you're going to treat it, it's like ants and termites and all those other sorts of invasive species, there's no point doing one bit of the structure. You've got to do the lot.
Yeah, by the way, I got a quote for someone to come and have a look, and it was in excess of $500.
You mean only $500?
Yeah, that's to look, that's not.
Oh, just to look,
not to remove the infestation.
Oh, okay, just to have a look to quote you.
Yeah, that's right.
You pay $500 to get a quote.
No, that was the quote to come and look, not remove the possums.
Okay, I think we're a second-story apartment, aren't we?
They're all ground floor.
Yeah. Look, I might be ringing around and seeing if there are people who will come and give you a quote without charging you for giving you a quote.
Darryl, if you're in a unit development, like a strata unit, where you've got lots of little units and a roof a roof space that's common, you will probably find that the unit is only described in 2 dimensions, and so you need to see where the upper limit of your unit is, and it may be, depending on the way the buildings are structured, that the roof might belong to the individuals and not to the owners' corp.
Okay, so check carefully.
Thank you.
All right, and good luck. Fiona in Dalesford. How's beautiful Dalesford today, Fiona?
Oh, yes, it's sun shining. It's beautiful.
Okay, can you get a park in the main street on a Tuesday?
Yes.
Okay, unlike most other days of the week.
Well, towards the weekend it does get a bit tricky.
So I've heard.
Yes.
How can we help?
Just wondering, is there a length of period of time in which a bill needs to be paid? Legally?
Let's turn it round the other way.
Yes.
You can enforce a claim for an account that is less than 6 years old as at the time of, that is within 6 years of the last acknowledgement. So if I send you a bill today, then I can enforce that bill, subject to some other issues, for at any time within the next 6 years, and I can start the enforcement process by issuing a summons 6 years less 1 day from today.
Okay.
Are you owed money or do you owe money?
No, I've just received notification that I do owe on a bill that was dated January 2013. So it's the first time I've had any correspondence.
What? Nothing in between?
No.
At all?
No.
How much is it for?
It's $266.
And so the question...
I'd be very scam alert to something like that, Fiona.
Right.
Except if I was going to be scamming, I'd want a bit more money than $200 and it would be worth the printing.
No,
I was just taken back by the little amount that was owed and the time period in which it's taken to
because people are more
me.
curious about bigger bills and they just pay on smaller ones. And if you send out 1,000 fake bills for $213 and 1% of them come back, you're doing very well indeed. So does it look authentic?
Yes, well, it's more... I have received a phone call as well.
Yeah, but they can be fake too.
Yeah, okay.
Have they got all the details correct?
Yes, at this stage, yes.
And do you think you, in fact, acquired those services?
Well, it's possible because I did change communications
providers.
Yes, when obviously leaving
that one.
Yeah, Melbourne. So
I'm surprised that 6 years later they're even looking at you. But yes, they could issue proceedings. You're within 6 years. What I would be more concerned about is whether or not they make an adverse credit rating and what impact that might have on you than the $200.
All right, I've got a great text message. I was involved, says Mark in Geelong, in a court case where we lost and our barrister did such a bad job the judge ordered costs against the barrister.
There are increasing numbers of personal costs orders, John. So a personal cost
lawyers.
order is made against, you see them made in the probate jurisdiction and you can see them made generally by...
When the court is so disapproving of the way a case has been run, they're saying this should never have come to court.
Or inadequately prepared or whatever.
This should never have made it here.
Yes. Or shouldn't have come today, so I'm making you pay cost of today.
Wow. Graham and Morty Alec. Hi, Graham.
Hi, John and David. Mine is in regards to an extension that we're having done. Contract was signed in November 2015. Work commenced May 15. Was to be 258 days. It's now 730 days.
What? And they haven't finished?
No, not finished. Not by a long chalk.
But they're well and truly, they've started.
I'm sorry?
They have started.
Oh, yes.
Right.
So Graham, why are they still there?
Because they've done 14 days' work since December the 16th.
No, so one could argue, as your building contracts are a particularly unappealing document, with due respect to the people who prepare them, but there's a provision in most building contracts that can require you to have the builder to resume diligently on site. Why is the builder not coming? Have you overpaid the builder?
No, we haven't. We've paid all of our accounts on time.
No, that's but what you might find, what's the value of your building contract?
$270,000.
Ouch. But it might be that you've reached the point where it's going to cost more to finish than there is in the contract.
Well, they're rather a large company, David. I'd be surprised at that.
Okay. Then why would you not... you could make a complaint to the Building Commission?
I have done, David, but they tell me it's about 10 weeks prior to they being able to do much about it.
Oh, sorry. So this is because this is a domestic building disputes process.
Yes.
Yep.
Yes.
And you're too late, or is it because the queue's quite long?
Yes.
Is the problem the queue?
Apparently.
Is it?
Apparently, but David, I have a question. In the original contract that we signed, it made statements such as all painting, internal staining, etc., to be done by builder.
Yes.
When that was transposed to the plans,
yes,
which were signed at a later date,
yep,
that they in fact enclosed in that it was all the responsibility of the owner.
Then what you might need to do is consider what's called an application for rectification.
Right.
Right. So what you're doing is you're going along and saying, look, I accepted your quote. When you transferred it to a document, you didn't do it properly. So I need you to acknowledge that the deal was that you would do the painting and that's how you priced it. And if they say no, then it's an action for rectification. And you don't see them often, but you do see them. You come along and say, well, the agreement in all cases was that the painting would be done by the builder, and it was an internal error. So does that make sense to you? They give you a quote with a price and a scope of works, and they produce a document that's got exactly the same price and a reduced scope of works. It's an action for rectification.
All righty. I hope that helps you, Graham. And David, thank you indeed. David Whiting, our talkback lawyer, helping you with free legal advice.